Hi, this is Irina Shea, and this is part of our Wealth and Wisdom series. Today, we're going to talk about what if my estate plan is 20 years old? Okay, so I am going to share my screen and share my thoughts with you on this. So, very often we have new clients come in that say we have an estate plan, but it's 20 years old. It's from when the kids were young and we needed simple wills with guardians, etc. And they're not sure if it's a problem. Okay, yes, it's a problem. So, first of all, if the estate plan is 20 years old, likely your power of attorney is what's called stale. Often banks will not accept a power of attorney that is more than 10 years old unless it names the spouse. Even then, it is a little bit questionable. The bigger problem is your fiduciaries, right? Your executors, trustees, guardians are no longer optimal. So you had guardians for children who were now all over 18. You have executors who were maybe your siblings, but now you have adult children who can fill the role. There might have been trust till a certain age for children, which you may not need, or you may need to convert to lifetime asset protection trusts. But I can almost guarantee after 20 years, the people you named 20 years prior to carry out your wishes have very often changed. They've aged out, right? Aged out, they've moved children, now adults, to serve in these roles, all sorts of reasons. So fiduciaries are typically a change. The other thing that's changed in 20 years is your balance sheet. So presumably it's larger. And if it's larger, we need to reoptimize um, inheritance for children. Okay. So what might have been just basic kind of age 30 trust, now there's a whole lot more money and the children now married and there's grandchildren, right? There's all sorts of reasons to look at, consider lifetime asset protection trusts for children. We need to at least look at this and analyze it in light of the current balance sheet, not the one from 20 years ago. Okay. Your healthcare directives. Okay. Make sure there's HIPAA language in there. I've seen some that are so old, they don't even have the HIPAA language, which means they won't work. Doesn't really matter who you named. The hospital's not going to take it without HIPAA waivers. So that has to be current and in there. And then what I also see a lot, partial plans. People say, I did a will only. Like, that's great if you die. What happens if you're incapacitated? They're like, I don't know. Okay. You absolutely have to have a power of attorney and a healthcare directive if you became incapacitated. So without it, you're looking at a guardianship, which is a very expensive, complex, intrusive public process. So having a partial estate plan is not going to cut it. It's going to leave you more at risk. The will is actually the easiest component, right? It's black and white when you die. Incapacity is the messy part. And if you don't have power of attorney and healthcare directives, you are leaving an enormous gap. Okay. Also, you may have done an old will-based plan, but now you may consider an upgrade. What's that? An upgrade is typically to a revocable living trust-based plan. Why? You're older and your assets are larger, and that generally trends toward revocable living trusts as a better vehicle. We have entire explainer videos just on this topic that you can look at. But basically, are you due for an upgrade? Very simply. Okay. Um, and then, of course, have you moved out of state? State planning is state-based. If you have an old plan, it's from New York and you now live in New Jersey, you have to refresh this, okay? If you moved out of state. And then I don't need to say this, I hope, but if your marital status has changed, right? You are divorced, widowed, remarried, nothing in the old plan is even going to make sense. You have to shift everything, your beneficiaries and your fiduciaries, to reflect your new life and your life going forward. So some people just sort of leave this on the back burner, and then they come in a panic because either there's a medical scare or there's a big vacation, a trip where you're traveling together with your spouse, and you say, wait a minute, wait a minute, wait a minute. What if something happens? I'm pretty sure that our estate plan doesn't even say anything remotely like what we would want it to say today. So, our advice is please get ahead of that. The process really isn't as scary or overwhelming. What would be scary and overwhelming is if the old plan took place because you never changed it. So, we highly encourage you to review any old estate plans. We can look them over for you. We can likely start fresh, but if they look a-okay, we'll tell you. So um, we welcome you to go to our website at irinashea.com and click the Get Started tab. There is no charge for our initial consultations, and we'll give you our opinion. Thanks.